Very much, Mr Speaker. I'm rising as a member of the Justice and Electoral Select Committee to speak on the Criminal Procedure Reform and Modernisation Bill, which Labor is supporting now to the committee stages, and there has been quite significant debate over this bill. And while I agree with Mr Bridges that this isn't about a game, I think perhaps my view on it is somewhat different, because I think at stake are some fairly fundamental protections for people against, to ensure that they are treated fairly within the justice system, and that is not a minor matter. That is actually a very serious matter, which is why this bill has become so controversial and why the government did struggle to actually get support to move this bill along. So I don't think that everybody there was playing a game. I think there were really fundamental issues at stake. It contains a major overhaul of criminal procedure in New Zealand, there's no question about that, and in fact Labor supports the need for a substantial overhaul of the criminal procedure, and in fact established in October 2007 a review of criminal procedure in New Zealand undertaken by the Ministry of Justice in collaboration with the Law Commission. And we voted for this bill to go to Select Committee and gave substantial and serious consideration to the features of this bill, which is a substantial bill, 526 pages long. And as Chester Borrows indicated, this is a Select Committee that has worked well together, has been well chaired by Chester Borrow. But I want to note here that Charles Chevelle has played an exceptionally important role in both the Select Committee process and hearing of submissions and teasing out what was being said by the various submitters and looking in depth at the implications of this bill, and in a role of getting us to the point we're in now, where we still have a bill to proceed with. And I really want to acknowledge the intellect and integrity with which Charles Chevelle has dealt with this bill. As I said, it was stalled in Parliament because of opposition, and that opposition was substantial, and it wasn't people opposing it just for the hell of it. The government cannot and did not in the end ignore the substantial opposition to what was controversial, and an increasing number of legal experts were indicating concerns about the policy and of the bill as it stood, and that included the New Zealand Law Society, the New Zealand Bar Association and the Criminal Bar Association, and that opposition also followed criticism from the Chief Justice and the late Chief District Court Judge to aspects of the bill. So we're talking about a fair weight of opposition to the bill as it was. So we certainly agree that the principal statutes governing criminal procedure are out of date and excessively inflexible, and indeed there's still things to be done in that regard. And in my role as Labor's Women's Affairs spokesperson, I'm certainly very mindful of the need for victims of crime to not be unduly disadvantaged by an inflexible and out-of-date and slow criminal justice system. But we didn't believe that the bill as it stood would achieve the intended reforms, and as indicated had serious concerns about the implication of the bill for the public's access to justice when it was reported back. And we did have quite a substantial minority report outlining those objections, and they included the threshold for jury trials. Now, Simon Bridges seems to think this is not that significant a matter in his contribution that he's just made, but in fact this is a cornerstone or a fundamental part of our current system. So you can't start moving bits without looking at the wider implications of them, and we've had many people come to our Select Committee and talk about that one specific point about the threshold for jury trials, and in the end it is, as one person described it, probably one of the most fundamental parts of our democracy, because it is actually where directly citizens get to have a significant say on what happens to another citizen of this country. And the consequences, of course, of going through the criminal justice system can be very severe, both in terms of reputation but also in terms of incarceration, actual taking away of a person's liberty. These are fundamentally important things, and the importance of jury trials is a cornerstone of our system as it currently stands. Our minority report also looked at issues around defence disclosure, proceeding in the defendant's absence, compliance cost orders, and those were probably the four most major areas. And so we are pleased that in the committee stages the government intends to introduce an SOP that will address those concerns, and we look forward to that. And as Charles Chauvel has indicated, we will be putting forward further matters in a SOP at that point, and they include things like trials in absentia and sentencing indications, which, as Mr Chauvel mentioned, actually could perhaps be formalised in some way because they do appear to be working well. So we would agree that this legislation was needed, but that in fact it didn't do the work in a manner that was appropriate, and in fact led us down the track of some things that even the Attorney General had quite a scathing report on this bill, saying that it unjustifiably contravenes the Bill of Rights Act in a number of ways, including by allowing criminal trials to proceed without the accused being present, and by allowing the courts to order the retrial of an acquitted defendant if new evidence comes to light. These matters, when your own Attorney General is quite scathing about them, are serious. So we are glad that we have moved this on to this point, and I look forward to the committee stages of this bill at some point. But I do think probably we all need to recognise that there is more that needs to be done if we are seriously going to address the problems with the current criminal procedure system, which are excessive cost, excessive delay, excessive complexity and an outdated legislative framework. But to deal with those matters, and especially that last one, the legal framework, we are getting into territory which is around fundamental rights and about very, very serious matters that form the basis of our legal system, and we will need to make sure that any reforms adequately take account of those things. Thank you, Mr Speaker.